do that first. Okay, so I'm Noma Langam Charlie Moses. I'm a host here at Intellectual Chocolate. We have Ms. Robinson here, who is an attorney and a trademark specialist, who's going to teach us about the things that we need to do as business owners. I'm just addressing a question that I'm seeing here. It says, I thought this was starting at 1 p.m. And you guys started early. Will there be a replay of this? Yes, if you're a student at the Black Business School, yes, there will be a replay of this. You do get access to the webinars after they've already gone live. That's the first thing I wanted to address. And it is 1 p.m. Eastern Standard Time, right? It's 1 p.m. Eastern Standard Time. So maybe somebody missed that it was Eastern Standard Time. So in the East, in the United States, it is 1 p.m. I'm not sure where you are right now, but it's 1 p.m. Eastern Standard Time. But we can continue.
Awesome. So did they have any questions on the beginning part? Any questions on that?
Okay. I'm not seeing any questions yet. We just have one person who just wanted to know about whether there would be a replay, and I answered that question that we would have a replay. I did want to just give an example, even though you didn't solicit it, that I actually know of a person that started a hotel and called it, I think it was called Travel Lodge or something like that. And what happened was that they just thought up the name and started the hotel, built the building and did everything, established it, decorated it, and opened. And what happened was they had not, I would equate it to in the United States, where if you were in, let's say I live in the state of Massachusetts, and I thought there's no travel lodge in Massachusetts, but it turns out that there's a travel lodge somewhere else in the country, and their trademark covers the state of Massachusetts. So that means that I'm infringing on their trademark now by calling my hotel this, and then now I have to go through all the trouble of actually changing the sign of my hotel. It only changed slightly, right? But I still had to change the sign of my hotel. I had to change all my brochures, everything, my advertising, promotions, everything, and go through all those costs. When, like you said, the first thing that I could have just done before I started anything was hire an attorney to make sure that my name was okay, not just in my own state, my neighborhood, or whatever I know, but everywhere else that can be affected by what I'm doing.
You are absolutely correct. This occurs so much. It's very frequent. And a lot of it is because we don't know. We think that when we do our Google search, you do a Facebook search, you do maybe an Instagram search, oh, I'm covered, I'm good to go. The problem is, as you mentioned, it's a federal trademark. That means it covers the entire United States, okay? And with it covering the entire United States, what about the businesses that does not have an online presence? So when you did your search, you may have searched Google, you may have searched, Facebook, Instagram, but unless you was able to search every single business, in the United States, which we cannot, let's just be honest, we typically cannot and do not, you will not know. And to spend all of that money, the time, the hard work, the building your brand and your followers, to then get a letter that says, hi, I own rights to that trademark, and I'm requesting you to change your name, stop using it, right? If you do not, I will sue you. That could be very heartbreaking. So is that serious to check first? I did see a question come in.
Yeah, I see a couple of questions.
Okay, go ahead.
So one of them is in the chat, which was the person who said we started early, but she did also want to ask, can we also look up the company name on the federal trademark site? Yep. And there's two more questions after that.
Okay, great. So you're referring to the United States, I call it the USPTO website. Yes, you can look up a company on that website, but understand that it is a direct hit. What does that mean? What it means is that whatever you type into that website, they are searching for exactly what you type and nothing else, okay? The reason that I recommend you guys to hire an attorney, because not only can you not have the same trademark as someone else, you cannot have a trademark that's similar to someone else that infringes on their service or product. What does that mean? If you go to the trademark website, you type in apples, but you left the S off, okay? There's another company who have a trademark with the S. You thought you was okay. You're not okay. And they only gave you exactly what you put into the website. They're not going to give you anything that can be similar or confusing. However, when you fill out for the application, they will reject your application because there's a registered trademark that's similar to what you're trying to register. I hope that answers. If not, let me know.
Okay. So Carolyn says, if you register your domain name on a website, is that enough protection without getting a trademark?
No.
If you register your domain name.
Go ahead. What was it?
I was just repeating the question. If you register your domain name on a website, is that enough protection without getting a trademark?
No, it's not enough protection. The only protection that you're going to get for your trademark is if you register it with the USPTO, or you get a little bit of protection with common law rights, okay? And that's without doing anything, but I already explained how limited that is to your geographical location. But registering just your domain name, okay, you own the domain name, but you don't own the brand name. And when you own the brand name, now you're talking, because if someone have your domain name, right, or if someone comes out with something similar, you can possibly get them to stop doing that. But just registering a domain name isn't going to, give you the protection that you need to protect your company.
So it just protects your domain and nothing else, really.
You want to protect your brand name. So
right.
Whatever the name, and here's the thing, you want to protect, I tell people, protect what you will not be comfortable losing. Okay, so if you are not, for me, I'll use an example. True Lawyer is the name of my law firm. I am not comfortable losing True Lawyer. So a trademark is filed for that, right? If you are not comfortable with losing it and starting over from scratch, you want to protect it. If it's something that you're like, okay, maybe I'm selling eyelashes, right? Just for an example, but I'm not going to be doing this. I'm just doing this to make a little money. No big deal. You may not want to spend the money to invest into protecting it. But if it is a logo that you would not be comfortable changing or losing, if it's a brand name, then yes, a slogan, you want to protect it.
Okay, understood. So the next question is from Alicia, and she says, I apologize if this has already been covered. How do I learn if my business name is already trademark protected? I think we might have covered that in the minutes, but that's the question. She says, how do I learn if my business name is already trademark protected?
Okay, so I'm going to do a very quick overview because we did already cover this. The way that I recommend you hire an attorney to do a professional search. We use search software. We know what we're looking at. So we can do a, 360 search for you. That's the best way. Other than that, you can go and attempt to do it yourself by looking on the USPTO, okay? And you type in the name on the USPTO. If it is a direct match, they will pull up the name for you and they will show you the application, the serial number, etc. If it is not a direct match, understand they will say no results found. That does not mean it's available for you to use, because one of the requirements when registering a trademark, you cannot have the same logo, design, slogan, name as another brand, but you also cannot have something that's similar or can be confusing.
Okay. So Barbara Ann says, I have registered my business and set out to owning the logo to be trademarked. Lately, I learned that the registration was opposed and my registration is held up with filed extensions. What can I do?
Okay, at this point, they're opposing it. So now you're going to go into a legal battle, okay? I do recommend you contact an attorney because we have to review your file in particular to see why did they oppose it? Do they have legal bearings to oppose it? And what exactly is your specific reasoning that they gave for opposing it? However, when you're filing your registration, and I'm going to walk you guys from A to Z for those of you who aren't as savvy as her and know what opposition is, they do have the right to oppose it. Once they oppose it, you will have the right to respond. Once you respond, the trademark board, they will give you a response far as whose side they agree with, okay? If they agree with you, it will move on to publication. If not, you can appeal. This is why it's important to hire an attorney, because you may not be able to complete all of those steps on your own, but essentially you're gonna have to fight whatever they submitted if you want to register that trademark.
Okay. So I think I had a slight internet interruption here, so you kind of were not clear. So so for you guys, and if you're in the classroom and you heard everything that she said, just say in the chat, just say I heard everything, and then we can just move on. If not, then maybe she can repeat the last thing that she said, because it looks like we just froze a little bit.
Okay, let me know.
Okay. Oh, Joyce says I heard everything. So maybe the freezing was just on my end. So you said you were going to just do a quick step-by-step.
You're freezing again. Are you there?
I'm here. I'm here. Like I said, it seemed like we had a little bit of a connection issue there. But I was saying, you said you were going to do a quick step-by-step of how to go through the process.
Yes, let's do it step by step, so that way we're all, you know, on the same playing field, because I understand there's some experience and some newer business owners. When you first file a trademark application, preferably your attorney is filing it, okay? You file the application, understand that you are starting a legal proceeding with the government. This is a legal proceeding that you are starting. It's like a court case, okay? But you file your trademark application. For the first 3 months, you won't hear anything. They're going to send an email stating that they received your file. But besides that first email, you will not hear anything at all for about 3 to 4 months. That's just the amount of time that it takes them to process the amount of applications that they receive, okay? Once they receive your application after about 3 to 4 months, at that time, either one, they didn't find any problems with your application, which is amazing, and they're going to send it to publication, okay? When they send it to publication, they are now publishing it to the world, and what they are stating is that come one, come all. If anyone else feel that they have rights to this trademark, which would stop you from registering a trademark, at this time, say something, and they can respond and oppose, which is what the other young lady was speaking of, someone did to her, okay? They will have 30 days to do that, or they can request an extension. If no one responds, then it moves, it goes, if no one responds during that time, then I would say in about 3 to 4 months, you would get registered, okay? Now, we're gonna back it up a little bit. That's the perfect way. That's the easy, we found it, everything was awesome, no one opposed. We're about to get our trademark registered, and we're gonna have our fancy certificate, and we are, you know, great. We're protected, and now we're going to enforce it and make sure that other people do not infringe on our trademark, or we sue them, send out a cease and desist, etc. Okay? Now, we're going to back that up to when problems arise. You filed the trademark application. Took about 3-4 months before you heard from them, okay? If they find a problem with your application, they call it an office action. They're going to issue you an office action. What that means is that the attorney at the trademark office said either one is something simple, like send me a different specimen, or there's something what we call a substantial office action, which is we cannot register your trademark because someone else owns this trademark, or it's confusing to someone else, okay? You have to respond to their office action. You will have 6 months to respond to that office action, okay? If you do not respond, I'm going to stop here, guys, because I think she just got cut out. Can you guys hear me? Let me know if you can hear me, because I think she was cut off. Okay. Are you back?
My apologies, guys. I'm back.
Okay, awesome. So we're going to keep going. They said that they can hear me well. Okay. So I left off stating that when they send you an office action, this office action is coming from a lawyer, which is why I don't recommend you do it on your own, because you have a lay person trying to write back to an attorney, right? So you kind of want an attorney to write to an attorney. However, when they send you an office action, you must respond. They give you 6 months to do it. That deadline is hard. If you do not respond within 6 months, your application is abandoned, okay? You do not get your money back. You do not get your fees back. It's abandoned, okay? You'll have a short time to, contact them, let them know you didn't realize that your application abandoned. You would like to respond after that short period of time. If you don't respond at all, it's just abandoned and you waste your money, okay? If you do respond within that 6 months, that attorney is going to review your brief what you sent back. This shouldn't be, a couple of sentences that you type. Trademark is based off laws. If you don't know the laws, you don't know what to include in this brief when you respond. Your attorney would know, okay? So we respond back with a formal brief within that 6 months, okay? The lawyer at the trademark office is then going to read our brief, and either he's going to approve it and send it to publication, once again, announce to the world. Anyone have any problems, anyone want to claim rights to it? If not, we're going to register this trademark. If no one responds, we go to registration in a couple months, okay? Typically about 90 days, 90 to 120 days, somewhere in that realm. Now, if he do not approve your response, they will issue what we refer to as a final office action. So now they are going to say, hi, in lay terms, hi, I received your response. These are the concerns that I have. Please address them. You now have the same time period to address those concerns, okay? You do nothing, it will be abandoned. You do something, we can keep moving forward, okay? And what you should do is absolutely have someone to respond to that office action that know what it is that they're doing, okay? Once you respond to that office action, now they're gonna approve it, send it to publication. Let's move down to registration. You're proud, you're protected. If they do not approve it, you will have the opportunity to appeal, okay? Most trademarks don't go that far when they're done by a lawyer, because we have already done the search at the beginning before we even filed it. So we would know potentially if there's, some red flags with your trademark, that we're going to have to do this much work to get it registered. Things can happen. We don't get the final say as lawyers. The lawyers at the trademark office get the final say. So it could happen sometimes, but very rarely do it happen when attorneys is on file. It more so happens when you have done the trademark on your own and it was like red flags from the beginning that you did not address, and now you're having to fight it, okay? Or someone oppose you. If they oppose you because they feel like they have rights to it, then you could get into a legal battle with who actually deserve the right to this trademark and who have priority to register it. And when you appeal, because now you're going into litigation, the time frame on that can vary, because now we're doing a true, trademark litigation to try to get your trademark registered. Does that make sense for anyone? If I can clear anything up, let me know, because I know it's a new topic and I'm okay with doing that.
I wanted to ask just a very basic question, like from a business standpoint. If you're at the very beginning and you're trying to register this, isn't it just worth, your own time and everything just to not use that name, or not use that, since you haven't invested anything in it, and just go for something else rather than fight for something that hasn't really been established? For me, it feels like you're going through a lot in the beginning and taking a lot of what could be your starting capital and putting it into fighting for a name or fighting for a brand that isn't really established. What do you think?
Yeah, I absolutely agree with you. So when you first do the trademark search, if you have a professional attorney who have ethics, they are going to tell you. Like when I do my trademark searches, I tell my clients, I color code it: red, yellow, green. Green, let's file, we're okay. Yellow, okay, we may get an office action, but I think we can fight this. But I'm going to make you aware that, you know, it may be a fight to get it, which is okay. Red, stop, find a new name. You know, I can advise you what to do. I cannot force you to do it, but I will advise you. It's not worth it. You know, that's like trying to file for McDonald's. Why would you want to file for McDonald's and have to fight? You're not going to win on that one at all. But why fight for something knowing it's highly unlikely that you are going to be approved because someone else is entitled to that trademark already? It's a waste of money. It's not worth the headache. Literally, when you are searching for names for your business, you probably will go through searching 100 names before you find one that can be trademarked, because there's about 100,000 trademarks that was filed, probably more than that, so don't quote me on the number, but at a minimum, 100,000 trademarks was filed between January and March. That's this year. So the value of the trademarks that's filed, unless you have a name that's generic, it's not attached to anything, it's really something that's just foreign, it's a high likely that someone have already trademarked it, which is why it's very, very important to have someone do the search. If you feel comfortable on your own, you know, and money may be an issue, I totally understand that for many people. You can try to look on your own. If you see someone with Facebook, Instagram, you know, you Google, you see their website, you probably want to steer away and just select a different name. I totally agree.
Right. But also understand that you're taking a risk if you move forward without actually going through all the channels.
Absolutely. If you move forward, you are taking a huge risk. And you have to also assess, do you have the money to take that risk? Because if you had very limited funds and you put all of your resources into building this brand, you build it, you have your email list, everyone know you as the goddess Locks, or you know, whatever name you choose, and now you get a cease and desist that says stop using that name. Are you prepared to rebrand yourself? And for some people, I don't know who would say yes, you know, but for some people, they may be prepared, or they may want to take that risk. That it's not a risk that I would advise for business owners to take. Now, if you have spoke with an attorney and they told you it was in that yellow, that gray area where, you know what, we may get an office action, but I think we can beat this, I think we can fight it, then assess the risk, assess how much money you have available to fight it if it was to go that far, and then you can proceed. But other than that, absolutely, if an attorney tell you it's red, stop, find something else. It's not worth it.
So we have 3 questions. I'm going to read 2 of them, one after the other, because they sound similar.
Okay.
So I'm not sure if this is Caroline or Carolyn, but she says, what states do you work in and what type of attorney should I hire? And then Joyce says, is there a requirement to hire an attorney that is licensed in the state I file the trademark? So they're both kind of asking about what state to file in, and then what kind of attorney to hire.
Absolutely. You're looking for a trademark attorney. Trademarks are federal, so any attorney can file your trademark, because I practice in all states. So I have some clients in Atlanta, I have some in Washington, I have some in Chicago. I'm licensed to practice across the United States for trademark law because it's federal. What was the follow-up? I think I answered both.
Yeah, the first question was, what states do you work in and what type of attorney should I hire? So what state you work in is irrelevant because it's it's covered by federal law, right? And then what kind of attorney? I heard you say that you have to hire a trademark attorney.
Correct. And as an attorney, we're all licensed to practice law, right? We're licensed to practice whatever area of law that we choose to practice. However, I would recommend you file your trademark with an attorney that practice trademark law on a regular basis, because there's deadlines, there's very, you know, minute things when it comes to trademarking and how you file it and how you register it, you know, the description that you use, etc. You don't want anyone using you as the guinea pig, okay? They're learning while they're doing your trademark. You want someone that's experienced in this area. So if you were to get an office action, they will know how to respond and how to assist you. Versus if it's someone who's never done a trademark, they are truly learning on the fly. Not that they cannot do the job. We are all licensed to practice any type of law that we choose to practice. But in my opinion, I don't like to be the guinea pig for anyone. I want to go with someone who specializes or at least practice that area frequently.
So I guess to answer Joyce's question, that is there a requirement to hire an attorney that is licensed in your state to file a trademark? The answer is they can just be anywhere. It doesn't matter. So I'm just gonna mark those questions as done, and we have one more question. The next question is from Joyce. She says, do you have any recommendations on trusted sites we can visit to review all business laws within the states we plan to do business?
No.
You need me to repeat it?
No, I heard the question. Here's the thing. When you say all business laws, one, to answer your question directly, no, I don't. Two, when you say all business laws, each business is different, okay? It depends on what type of business you are doing. So if you are requesting trademark law, right, I can point you to the laws of trademark. Now, many of them are cases. You may or may not be able to read the cases and understand how the law was derived from that. But you can also visit the USPTO website, uspto.gov website, and they kind of break down the different, how to file a trademark, etc. But business laws, most of that go on what type of business are you running? What are the different laws that apply to your particular business? And it's not a one size fit all. There's way too many laws for a one size fit all. If you have access to LexisNexis, which is what attorneys use, so you may not have access to it, but if you know someone who have it, certainly all of the case law is housed there, or you can visit a law library that you can find at any law school. But that may be a little bit too overwhelming for you to review on your own.
Okay, so the short answer is you don't know, but I think what you added was helpful. So that question is answered. Those were the
particular that she's looking for. Maybe if she can narrow it down, because you're not going to find one site that says you have businesses ranging from hospitals to dog care, right? So those laws are going to vary, and you're not going to find one site to kind of break down the laws for all of that unless you're going to the law library or LexisNexis, where it houses all the laws, but you still have to know how to access it.
Okay, so she says thank you. She's got it, and got it regarding my business law question. Okay, so it sounds like you answered her question. Okay, so all our questions have been answered. What was the next thing that you wanted us to kind of be aware of?
So one of the things that you want to be aware of is once you get the trademark. So we talked about the importance of the trademark. We talked about how to file and get your trademark registered, okay? Once you get the trademark, understand that the trademark is only good if you enforce the trademark. Having a trademark and not enforcing it is kind of pointless, right? You did all of this work to be protected, but then you're allowing copycats to copy you. It happens every single day, okay? When you get your trademark certificate, be happy, but also make sure you are enforcing your rights. What does that mean? When you see other companies infringing on your brand, using your logo, stealing your content, or whatever you have trademarked and protected, make sure you send out cease and desist letters. You don't want to have a trademark and then never monitor it and everyone is still, you know, copying you. That kind of defeats the purpose. So just make sure that you maintain your trademark and you enforce your trademark, similar to Beyonce. Any Beyonce fans here? Maybe no?
I don't see anybody putting their hand up.
Okay, so if you are a Beyonce fan, you know Beyonce does not play about her brand, okay? She came out, anything she comes out with and people steal, her attorneys are quick. By the time it hit the media, in 24 to 48 hours, she is sending out cease and desist letters. She's letting you know, stop using my brand, I have it protected, this is your warning. If you do not stop, okay, I will sue you. And she's serious, she will sue you. It does not matter because you have a t-shirt company and you are a small fish in the pond, she will sue you. You want to take your brand as serious as Beyonce. If someone is infringing, a cease and desist letter should be sent to them to make them stop. If they do not, you sue them, okay? And litigation for trademark law is pretty expensive. Most people will stop using your trademark because they do not want, you know, the expense of litigating when they know they're in the wrong. In addition to that, another thing that you can do, you can literally, like trademarks get, when you have a registered trademark, you get protections that other business owners are like just surprised at. Let's just say for True Lawyer, okay, you are going to go to an event and you're going to show up as True Lawyer. No, you're not, okay? What's going to happen is you're going to pay your money for that event and you're going to be registered. It's going to be the day before that event. I'm going to send the event host a letter, letting her know that you're infringing on my trademark and requesting that she do not allow you to display whatever you're displaying at her event if you use anything with my brand on it. If she does, she will be sued as well. What does hosts do? They pull it. They say, nope, you can't be here unless you change it. Can a business change overnight? A small business? No, which means you lost your money. Right. If you have something on Facebook, if you have a website that infringes on my brand, I can send a letter to the website host and have them to take down your website because it's infringing on my brand. So it works really well for the business owner that's protected to enforce her rights or his rights, to enforce the rights that's given to their brand, but also think of the flip of that. If you are infringing on someone, they can do the exact same thing to you, okay? They can make you stop infringing on their brand. Aside from just suing you, they can get quick remedies by going to the person that's allowing you to do it. Whether it's a website, take the website down. It's an event, don't allow her to be present at that event if anything has my brand name on it, okay? So you wanna be aware of that because I don't want any of you guys to be in a situation where you're on the opposite end. You wanna be on the, I'm protected, I'm enforcing, because it's better on that end. We're a lot happier.
So we have a couple of questions. Barbara, I see your question, and Chandra, I see your question. Joyce raised her hand, and I think that the reason she raised her hand was that she was a Beyonce fan. So I just wanted to acknowledge that. But before I go into the other two questions, I wanted to just kind of, you know, again, as well as being a host here, I'm also an instructor in the business school, which most of the people who are on this webinar are students in the business school. And they're obviously taking different business courses in the business school. And realistically, a lot of the students in the business school or the business owners who are taking courses in the business school are small business owners. And I'm just wondering, how likely is it that they're going to have the time and the money to really, I'm not disputing that they should do what you're saying, but how realistic is it that they can keep threatening people with an attorney? Doesn't it cost money just for the attorney to write the letter for you, or do you write it yourself? Do you understand what my question is? It just seems to me that it could become costly for them, especially being a small business owner, to kind of have all these attorney actions trying to protect themselves, which they should do, but how realistic is it that they can do that and do it consistently, or to the degree that you're saying they should?
Absolutely. So you do have to choose your battles, okay? You have big brands that will rip your company off. You have very small brands that will, rip your company off and steal from your brand. So you do have to choose your battles in the sense of, I have limited funds. Who do I send the letters to? Who do I just say, you know what, it's not worth it? Okay. So you can kind of make that discernment on your own. But another thing you can do, and this is just a little hack, if money is really tight for you and you want to enforce your brand, maybe you pay the attorney the first time for a cease and desist letter. And okay, now you see the language that's on the cease and desist letter. So moving forward, you're going to send them out yourself. Now, I will tell you, it's something that I could be biased because obviously I'm an attorney, but it's something about you sending out a letter and me sending out a letter. When you send it out, they're like, oh, not really serious. When I send it out, they stop, right? Or they understand there's a consequence for not stopping and they respond. However, when money is an issue, if your business is very, very small, you may not be able to do some of the recommended things until you grow. Okay, if your business is not very small, and you do have revenue that's a cost of doing business, you add it up, similar to buying products, and you write it off at the end of the year.